the question about the definition as such. I had a question about the specific issue of the principle of superior liability. And in particular, the question of whether your law has provisions so that if torture is committed, there are appropriate provisions so that superiors who disregard warning signs about the risk of torture can also be held criminally liable. And the standard formulation is that there can be liability if the superior, and I'm quoting here, fails to take all necessary and reasonable measures within his or her power to prevent or repress the commission of torture. Now, the main, as I understand it, and please feel free to correct me if I misunderstand it, but the main provision of your law, Article 126 of the Criminal Code, says that a superior can be liable if he orders torture. But that's not the same thing. Under superior liability, a superior need not have ordered the torture in order to be criminally liable. Instead, the key is his failure to take affirmative measures when there are warning signs that there's such a risk. Now, I think you addressed this some, or tried to address this some in, I think it was paragraph 18 of your report, when you say, well, under our law, a person need not be the actual perpetrator, but he can be prosecuted if he is an accomplice. And maybe that gets at this. So maybe you're driving at the superior could be liable as an accomplice. But that doesn't seem to work because the definition of accomplice in your criminal code doesn't reach the superior who simply fails to take appropriate steps to prevent or punish. The definition in Article 40, which your report quotes, which is how I found it, it says, Article 40 defines an accomplice as anyone who, and there are three possibilities. The first is that he instigates the criminal act. Well, that's not what we're talking about. The second is that he reaches an agreement with others to commit a crime, torture. Well, that's not what we're talking about here. And the third is knowingly provides the author of the crime, the torturer, with arms, instruments, et cetera. And that's not what we're talking about here. So none of these describe the superior who, knowing that there were widespread allegations of torture, failed to take appropriate steps to prevent future cases. You know, what does he need to do? Maybe he needs to institute new procedures. He might not even know of a specific case. He just knows there is the possibility out there. Institute new procedures. Make sure that subordinates obtain training so they don't engage in torture. Maybe make an announcement that torture will not be tolerated, but change the environment. And failure to do any of these things doesn't bring him within the definition of accomplice, but the criminal law still needs to cover him. So any thoughts you have on this would be welcome. But I do think it's a very important issue, and I think the main question here is, are you prepared to consider and adopt legislation that would provide clear criminal liability based on the principle of superior liability for torture?